Hi, I'm Matthew Mobilio, founder of Mobilio Law. In this video, I'm going to talk a little bit about the factors that the court considers when entering a custody or visitation order. When a custody dispute arises, the main consideration for the court is, of course, the best interest of the children. As custody law has developed, the courts have considered a number of factors when determining the amount of custody and visitation to award parents involved in a custody dispute that will serve the best interests of the child. Those factors have become a part of Pennsylvania law and must be considered by the court. Those factors include which party is more likely to encourage and permit frequent and continuing contact between the child and another party, the present and past abuse committed by a party or a member of the party's household, whether there is a continued risk of harm to the child or an abused party, and which party can better provide adequate physical safeguards and supervision of the child. There's also a factor to consider with regard to child abuse and involvement with protective services. The court also considers the parental duties performed by each party on behalf of the child, the need for stability and continuity in the child's education, family life, and community life, the availability of extended family, the child's sibling relationships, the well-reasoned preference of the child. Now, the court will only consider this depending on the child's age, and that will be discussed in an actual future video. The attempts of a parent to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. Which party is more likely to maintain a loving, stable, consistent, and nurturing relationship with the child, adequate for the child's emotional needs? Which party is more likely to attend to the daily physical, emotional, developmental, educational, and special needs of the child? The proximity of the residence of the parties, each party's availability to care for the child or the ability to make appropriate child care arrangements, the level of conflict between the parties and the willingness and ability of the parties to cooperate with one another. A party's efforts to protect the child from abuse by another party is not evidence of unwillingness or inability to cooperate with that party. The court also considers, of course, the history of drug or alcohol abuse of a party or a member of the party's household, the mental and physical condition of a party or a member of a party's household, and then the catch-all, which is any other relevant factor. Now, the weight to give each factor is in the court's discretion. Accordingly, it is up to you and your attorney to highlight and emphasize those factors which weigh in your favor. If you have questions about the factors the court considers in determining custody and visitation, contact me today for your free, no-obligation case evaluation.